Real Lordship. Lordship, I beg to mention item number 4.
Writ petitions are allowed.
Obliging.
Lordship, I beg to mention item number 26.
26.
Yes, Lordship. Lordship, this matter may listed after 3 weeks. I am for the respondent number 22 to 27.
Okay.
The consultant also taken from the appellant and
You are for respondent.
yes, Your Lordship.
On the prayer of Mr. Your name, please.
T. Paul.
T.
Paul.
T. T. Paul.
Yes, Your Lordship.
Learned counsel for the respondent number 12 to
22 to 27.
22, 27. And on the consent of the learned counsel for the parties. List this matter after 3 weeks.
Real Lordship. Lordship, I beg to mention item number 4.
Item?
4.
Yes.
My senior leading counsel is out of station or some personal difficulties. List this matter after 2 weeks. Madam.
On the prayer of Mr.
M. Lago.
So and so learned counsel appearing, no, not only prayer. Mr. So and so learned counsel appearing on behalf of Mr. Titi Tara, learned counsel for the petitioner. Appellant submits that Mr. Titi Tara is out of the station.
Item number 4.
Huh?
Item number 4.
Item number 4, sorry. Yes. You're for? You're for?
FL and petitioner.
Petitioner.
Yes, ma'am.
Okay, and on the prayer of Mr. So-and-so, learned counsel for the petitioner. This matter after 4 weeks.
Yes.
My lord, item number, in meantime, I will find my attorney.
Which one?
Item number 4, I'm the respondent.
Okay. In the meantime, the Mr. So-and-so learned counsel for the respondents may file this affidavit, file the affidavit of opposition.
May your Lordship. Lordship, I beg to mention item number 13.
13.
Yes, Your Honor. I'm for the petitioner. And Your Lordship, the matter may be listed after 4 weeks.
Why?
As the leading counsel is having some personal difficulties, Your Honor.
On the prayer of Mr. So-and-so learned counsel for the petitioner on the ground that the leading counsel, Mr. Who is leading counsel?
Oh, yeah, this idea.
This learned counsel has some personal difficulty. Mr. My personal difficulty come up. List this matter after 4 weeks.
Obliging.
Yeah, Madam. I would like to mention item number 25.
25.
Yes, Madam.
Yes.
Mr. J. Gini, Madam, the leading counsel is out of station. So
On the prayer of Mr.
my name is
learned counsel appearing on behalf of Mr. J. Gini. List this matter after 4 weeks.
Madam. Obliged.
Yes. Finally corrected.
We have filed in BNS.
Yes.
Matrimonial lordship, challenging the that's impugn order dated 23rd August 2023 and
9th of September 2022. So case is reported Honorable POCSO Court at Bombdila. So what happened, Lordship, on 23rd day of August, the court below has fixed for the 313. But what happened on that day? Petitioner along with junior counsel went to there to take adjournment because leading counsel was in medical ground. So prior to 23rd, the leading counsel was because of health issue. So I have annexed in my medical document page number 12 also. So what happened on that day? London court below has without that's giving the adjournment directly recorded the 313 also. And in that process, what happened? This junior counsel has supposed to file the application under 315(1)(a) of the CRPC that accused person to be competent witness along with the defense. But London court below has not given that opportunity. So
What's the result? What was the result?
the result, what happened after that? The London court below has fixed the matter on 9th of the September for the final argument, without giving opportunity of that to adduce the defense individual. So thereafter, Lordship, again on 9th of the September, petitioner along with their counsel was on the way from Sepa to Bombdila court. So on the process, what happened, Lordship? Before reaching the vehicle, got some problem. So
How do we know? How do we know all that?
Lordship, I'm just submitting the fact.
Is it not kind of Mangran Kahani?
No. Lordship, see the next, that's Indian order, 9th of the September. Lordship.
Where is this?
That is in page number 23. Lordship. So on that day, what happened, Lordship? Before reaching that council, the learned court below has already passed the order that the case is fixed for the judgment on 19th September. Learned counsel may submit the respective argument before the date of judgment, without giving any date for the argument also. Directly fixed tomorrow is the judgment. So particularly this is the procedural lapses. They have not given any opportunity. Lordship. So we want to use the evidence, defend evidence, and
How many defense witnesses?
witness. Lordship, we have all to tell, including this accused, 3. Lordship.
Three.
Yes.
Yes.
Your Lordship, they have annexed the IA for seeking to adduce evidence, Your Lordship.
Yes.
So what my humble submission would be, Your Lordship, let this IA be considered by the learned trial court and proceed with the final hearing, Your Lordship.
Will dispose of.
Yes, we'll dispose of, because otherwise it will hamper the trial proceeding, Your Lordship.
Heard Mr. T. Topu, learned counsel for the petitioner. By this revision petition, the petitioner has challenged the order dated 09/09/2024. When did you file the IA?
Yeah, Lordship, what happened? We were supposed to file that day.
That means
because we
it's
are
not
giving
filed.
the dinner.
On which date? 09?
And
09 or 20?
23rd, Lordship.
Okay, where is that 23rd? Where is 23rd order?
23rd order is page number, Lordship. Page number 11, Lordship. Page 11, and so on.
Okay, then in that case, 23rd 08/2024. And 09/09/2024, huh? Passed by the passed during the proceedings. In the POCSO C oblique number 04/2023. In SEPA WPS case number 02/2023. Under section 376 within bracket 2 bracket close bracket F bracket close bracket J bracket close page 23, huh? So in IPC read with section 6 of POCSO Act by the learned special judge Boxer, West Kamek, East Kamek and Tawang districts, Arunachal Pradesh. Next para. You write and heard Mr. T at the London Edition PPR on top. Next para. It is the case of the petitioner that on 23rd 08/2024, when the matter was taken up by the London Special Judge Boxer, the learned counsel for the accused could not appear before the court due to his illness. Where is this hospital, Alphabet Hospital, Nirjuli? You are staying here?
Oh, Lordship, after that, he was fine. After 2 days, he was fine. After 2 days,
The
illness.
council was here.
Council was, Lordship, he was 4 days back, 4 days prior to that, he was in Itanagar. But suddenly, some illness, viral.
Pain in the soldier, so and so, 4 days. What is this? That too, Alphabet Hospital, Nirjuli.
They are residing here.
Very hard to believe. Anyway, due to his illness, Mr. However, the junior of the learned counsel, Mr. L. Siri, within bracket junior. No. Who is the counsel?
Leading counsel is Tapio Lamu. Junior counsel is Elsie.
In that case, learned counsel, so no, could not learned counsel, Mr. Tapio. El
Tapio
Tapio.
Lambo.
El
T Lambo, T Lambo.
T Lam, no. Just give the name, huh? Please. Then so and so continue, huh? Please. However, his junior, the learned counsel, Mr. El Siri. Why El Junior? His name is El Siri Junior.
Yes, Tapio Lambo is the leading counsel and El Sering.
But why it is written El Siri Junior? He's
There
known
is,
as El Siri Junior.
there is two councils are there with the same name, so they usually
Okay,
use.
Junior, within bracket Junior, huh? Prayed for adjourn of the matter. On same day, you have filed the IA.
Actually, that junior counsel was supposed to file the IA, but not what happened. The court was very hurry to pass the order.
That means not filed, it is not filed.
So that opportunity was not given. That is,
It's all hard to believe.
not so bad.
Anyway, don't disturb. It's okay. Please stop. And prayed for, and was on the verge of filing an application under section 315 of CRPC. What is this application? Application is, which one is the application?
Application is also page number 15.
Annexure 3.
Annexure 3, page number 15.
Then what is this annexure to page 21?
That is lots of other defense evidence, supporting the defense evidence.
For allowing the accused person to adduce evidence. List of. Thereafter, have you filed these applications?
Lordship, this application was not able to file because court was, Lordship, only matter was taken up. The junior counsel was actually
please stop.
given for instruction to adjournment.
Thereafter, another application was ready for filing of the list of defense witnesses on behalf of the accused. The next paragraph. The learned counsel for the, Mr. Tito, learned counsel for the petitioner submits that despite the prayer of the learned counsel for the learned junior counsel for the appearing for the accused, and the prayer for allowing them to adduce evidence in the defense of accused person, the learned special judge Bokso hurriedly was the order dated 23/08/2024, fixing the case for final argument on 09/09/2024. Thereafter, on 09/09/2024, on what you did on that day?
Lordship, on the way from Sapa to Bomdila, but due to vehicle problems, it could not reach timely of it.
Otherwise, you would have argued the better.
There is,
If I record your excuses, I'll reject the ground. It's better not to record. Because this is not believable. Absolutely. Listen. And what is that? Last. Thereafter, on 9/9/2024, without allowing the petitioner, the petitioner, the learned counsel for the petitioner, accused petitioner, fixed the matter for judgment on 19/09/2024. Therefore, Mr. Tito, learned counsel for the petitioner, submits that the learned special judge Bokso has deprived the accused of his right to adduce evidence on behalf of him, adduce evidence of defense. List of as such, the special judge, the learned special judge Bokso Bomdila may be directed to allow the accused petitioner to adduce defense witnesses, abuse evidence,
My lord,
and defense witnesses.
Your Lordship, let the learned court below consider this application first, because in 313, the accused may not have opt for adducing the defense.
No. It's his submission.
Okay, Lord.
This next paragraph. Having considered the submissions of the learned counsel and not being opposed by the learned additional PP, that the opposed by the learned counsel with learned additional PP, I deem it appropriate to direct the learned special Judge Foxo from Bomdila to consider the application, which is not filed.
Lordship, we were supposed to file. Lordship.
Direct them to file, your lordship.
I deem it appropriate to allow the accused petitioner. No, allow the learned counsel on behalf of accused petitioner to file the appropriate application and along with the list of witnesses for consideration by the learned special judge Foxo Bomdela. Accordingly, the petitioner is directed to accused petitioner is directed to file appropriate application seeking
Reducing.
application seeking to allow him to adduce evidence and and evidence and witnesses, if any, in his defense. List of on filing of such application by the accused petitioner, the learned special judge Boxo Bomdila shall consider and dispose of in accordance with law. List of. Needless to observe that if an accused is not allowed to adduce evidence and witnesses, it may hit the principle of a fair trial. List of. Next paragraph. The criminal remedial petition stands allowed and disposed of.
Your lordship, they may be directed to file within 3 days.
Within 3 days, huh? Yes.
Today, tomorrow is fixed for the judgment.
Huh?
Tomorrow is fixed for the judgment of the landed court below. Landed court below today, tomorrow, so tomorrow is fixed for the judgment.
In that case, in view of the order passed above, before that, huh? Last line, before the last line. In view of the above order, the order dated 09/09/2024 shall remain suspended. Shall remain suspended till
Consideration of
till the application that may be filed, that is the application which is been directed to be filed is considered.
Yes.
Considered and disposed of.
Yes, sir. The time may be stipulated time may be given.
3 days or 4 days. 3 days, make it 3 days.
Yes,
Or
local
4 days.
council,
I have to collect my witness from village area because
but
You have already filed with
First application has to be
application will be considered and next date.
4 days.
Huh?
Within 4 days.
within 4 days from today, your lordship.
Within 4 days from today.
Yes.
You get it ready before lunch, huh? Get it ready before the lunch.
Okay. Deeply obliged, your lordship.
You, yes,
May your lordship, this application has been filed, jointly filed by the petitioner under section 482, corresponding with the section 528 of BNS, your lordship, for quashing and set aside the New Delhi PS case
MS
number.
heard MS so learned counsel for the petitioners. By filing this application, by filing this petition under section 528 of BNSS 2023. The petitioner have prayed for quashment of the criminal proceedings in GR case number 287 of 2016 under section 148, 149, 160, 323, 354, 427 oblique 34, case 2 of IPC, pending before the Court of Chief Judicial Magistrate, UPR, on the basis of settlement.
Yes, Your Lordship.
Mr. Call for the scanned copy of trial court record. Call for the scanned copy of the records from the Court of Chief Judicial Magistrate, UPR. Mr. Gitado, learned additional PP, appears for the state. Next, pending production of so and so, the further proceedings of criminal case, the further proceedings of GR case number so and so, 287, 2000 remain suspended. List after.
Your Lordship,
For-
stay order may be granted, Your Lordship, until this matter is resolved.
Hmm?
Your Lordship, stay order may be granted until this matter is resolved, because next hearing is on this 23rd of September, Your Lordship.
Have you heard the order?
Yes, Your Lordship.
Have you heard the order?
Yes, Your Lordship.
What is this? What is that?
Yes. It's
What
on-
order I have passed?
Yes, Your Lordship.
It's not audible.
No,
Order is not audible.
yes, Your Lordship, not audible.
Further proceedings of the GR case number so and so shall remain suspended,
Thank you, Your Lordship.
pending production of the trial court record. Anything else?
No. Deeply obliged.
This issue pertains to whether mixed question of fact and law. My case is that mixed question of fact and law cannot be decided as a preliminary issue. So the facts of the case, man.
Yes.
Now, what happened? Being deserted and abandoned by my husband.
What is the other? Where is the husband? You are,
I have taken Dusty, my lord.
Why-
On the last occasion also, your lordship has given them time, my lord, to appear. It
you
has,
are. Decree of divorce has been granted.
no, my lord, I have filed a restitution petition
Okay,
before the district judge, my lord.
yes.
It was dismissed on the ground that there was a
Okay,
kebab.
ma'am.
And I am disputing that there was no kebab at all. So this is a mixed question of fact and law. On the issue of mixed question of fact and law, it cannot be decided as a
What is
preliminary issue.
mixed question of facts?
I say, my lord, there was no kebab. There was no kebab held.
If you say so, is it a mixed question of facts?
Because it
And
has
law.
to be, the res judicata has been applied.
Say that, say that.
Judicata has been applied.
You are denying the kebab.
Yes, my lord.
It cannot be a mixed question of law and facts.
No, it
It will
has
be it will be a pure question of facts.
facts and law, you know, because the res
Res
judicata.
judicata is a mixed question of facts and law.
Yes, yeah,
But you are denying
yes.
your statement, denying the veracity or the existence of kebab
Yes,
is pure question of law, a question of facts.
I say, my lord, this is a fact and law. I have one judgment. I have one judgment.
Let us see.
My lord.
If it is not correct, I'll impose a court.
No, my lord. But in fact, my lord, what happened? First, my lord, this respondent had filed one divorce petition before the additional district judge Basar, which was dismissed. And the decree was also drawn by saying that both are Christians, so Christian marriage would be applicable, my lord. So even if there is a kebab decision, that would be a nullity, my lord. My lord, 2022 7 SSC. 644, my lord.
Just read it, just read it.
Yes, my lord. I'll start with para 16. The matter has been examined by this court in a judgment reported in Ramesh B. Desai versus so and so, my lord. Sub-rule 2 of 14 Rule 2 CPC lays down that where issues of both law and facts arise in the same suit, and the court is of the opinion that the case of any part thereof may be disposed of on an issue of law only, it may try that issue for jurisdiction of the court or a B or a bar to the suit created by law for the time being in force. The provision of this rule came up for consideration before this honorable court in so and so. Though there has been a slight amendment in language of Order 14 Rule 2 CPC by an amendment, so but the principle enunciated in the above quoted decision still holds good, and therefore can be no departure from the principle that the court confers no jurisdiction upon the court to try a suit on mixed question of law and fact as a preliminary issue. And where the decision of the issue law depends upon the decision of the fact, it cannot be tried as a preliminary issue. Para 16, my lord.
You show me, I said, there's no dispute, there cannot be any dispute that plea of res judicata
Yes, ma'am.
is a mixed question of fact and law.
Yes, ma'am.
What I'm on is your statement denying the existence of Keba
Yes, ma'am.
or the authenticity cannot be a mixed question of law and facts.
What I am saying, my lord, they have
There are two things.
Yes,
Don't mix it up.
yes.
One is your statement
Yes, ma'am.
or your submission
Yes, ma'am.
that there was no Keba.
Yes, ma'am. What-
Is it a mixed question of law and facts?
Because if
What I'm saying is, res judicata may be a mixed question of facts and law,
ma'am.
but your statement denying the Keba
Yes, ma'am.
cannot be a mixed question of law and facts. It's a question of facts only.
Can be, my lord.
Not can be, it is.
What I say, my lord.
So what you are trying to show from here?
Yes, ma'am.
You are trying to show that res judicata
Yes, ma'am.
is a mixed question of facts and law.
Yes, ma'am.
That we have agreed. I
Yes.
want you to show us that your statement,
Yes.
the statement of denying the,
Yes. I will.
you are not getting me.
Now, there is a statement in my petition, my lord.
Heard Mr. B. Fisher, Learned Counsel for the.
But I will satisfy, my lord. On the facts also.
It's all right. Problem is, what is to be done? This was service of notice.
Well, on two occasions, my lord, Justice Kaushik has also given time, my lord. Your lordship has also given time, my lord.
We'll give another time.
It would be, my lord,
Are you staying together? And
No,
you,
my lord.
you have been deserted.
I have been deserted, my lord.
Do you have the children?
Yes, my lord.
Huh?
Yes, my lord.
How many?
That I have to ask, but I have children. What I say, my lord,
You have a child or you have a children?
children,
Okay.
yes. They, some are major, my lord. So what I am saying, my lord, 14, my lord, there was a dispute between one,
No, prima facie, court should have been examined, allowed you to adduce evidence.
yes, my lord, that is my issue, my lord.
Just because some other person has produced the documents,
No.
relying on this cannot be dismissed.
Yes, my lord. No, what happened, my
But
lord?
other thing is the restitution petition,
Yes, my lord.
is it maintainable again?
Yes, my lord, I have filed under section
The
32,
larger issue,
section 32 of Divorce Act.
yes,
Section 32,
let us see. Divorce Act.
Divorce Act. Section 32, my lord. May I read, my lord? Petition for restitution of conjugal rights. When either the husband or a wife,
It applies to, what is your,
I'm Christian.
how you solemnize the marriage? Christian,
Well, what happened, that's why I'm saying, my lord, the additional district judge, my lord, has passed a decree, my lord, that the Divorce Act would be applicable to the petitioner and the respondent.
Divorce Act will apply.
Yes, my lord. That is a decree, my lord. May I please come to page. That has not been denied by the respondent also, my lord. Page 42. my lord. It's a nullity, my lord. Page 42 is the judgment. Page 46, my lord, para 8 would be relevant, my lord. Page 46, para 8.
46.
Para 8, yes. Sir. As per section 2 of Divorce Act, so and so, a divorce petition is material under the Divorce Act 1869 if any of the party is Christian at the time of filing of divorce petition. In the present case, both the petitioner and the respondent are found to be Christian at the time of filing the divorce petition. Therefore, the present divorce suit ought to have been filed under Divorce Act so and so. However, the petitioner filed the instant divorce petition under section 9 of so and so CPC. As stated earlier, the decree of divorce can be granted on cogent legal grounds provided under the law, and since the parties are Christian, the present suit is not maintainable in the present form, as detailed grounds of divorce is available to the parties under Divorce Act 1869. The first issue is answered in affirmative. Now, para 10, my lord, 47. In view of the determination
How
of
your
the,
marriage was solemnized?
that is not the issue, my lord.
That would be an issue.
Because there is a decree, my lord, page 48, my lord. Page 48, may I please come to. This is a decree, my lord. Decree drawn by the district court. Now, this decree has not been challenged. This has attained finality. Now, basing on this decree, I have filed, my lord, restitution petition. May I, my lord? My lord, may I come to page 110. This 110, my lord, 14 August 2019. The Kava decision has relied on this complaint. This complaint is relating to the petitioner and Miss Yame Padu, my lord. This is not for a divorce petition. This is regarding extramarital affairs. So in the case of extramarital affairs between the petitioner and some other third person, how there can be a divorce?
It says there was given by me on the date of 4th September to the for
Yes, ma'am.
divorce compensation.
My lord, page 110.
Where is cover decision?
Cover decision, page 78.
28.
78.
There's an agreement also.
No, this is a cover decision.
Page 76.
This is a dispute between the parties in past. Now, page 78, this is relevant. Second part, first part also. Srimati Yapi Ragmuk and Sri so and so have been married dispute since 2006. And for 5 years, they have contested the divorce case at additional so and so has won the case. Later on, so and so lodged a complaint before the DC against Sri Yame has an extramarital affairs with her husband, and she kept him as husband. After receiving the said Deputy Commissioner so and so, Tato so and so, dated 14 August 2019.
Sir, let us fix for hearing. We'll give another chance. We'll have to hear him. It's such a complicated matter.
Because what I am saying,
Facts are so complicated. Just hearing you, I mean, it may not be,
I will make it easy.
it may not be fair.
Well,
All right.
well.
It's not that we're disbelieving you,
Yes,
but let us give him a chance. Because it's between husband and wife.
yes, ma'am. The sole contention in the restitution petition, their written statement was that there was a kebab. That is their case. And this preliminary issue was prepared, my lord.
How
But
you'll be happy if court grants you a right of.
But
if-
still then this kebab decision, my lord. Yes, ma'am, the trial court. Ma'am.
if he doesn't want you, can you live happily with him?
Obviously, my lord, why not? I will try my best to live with her, my lord, or to live with him, my lord.
Forget it, move on.
The core issue is, my lord,
And you have the major kid also. I mean, your kids have become major.
my lord. My lord, this, I cannot let this order stand, my lord, because this cover decision has been, my lord,
Is there
Taken-
is there any interim order?
no, my lord. Because it has been finally, my lord, disposed of.
Disposed of,
Yes, my lord.
rejecting your petition.
Restitution petition on the ground that there was a cover.
So there cannot be any interim order also.
Yes, my lord.
There cannot be any interim
No, my
order
lord,
also.
what will I do with the interim order, my lord? I need a
Yeah.
final order, my lord.
Mr. BP Learned Counsel for the petitioner. None appears for the respondent despite service of notice and giving opportunity twice by this court. This- Next paragraph. However, considering that the issue involved pertains to the matrimonial dispute, we the petitioner has sought for restitution of their conjugal right. Comma. Let this matter be admitted and list for hearing after 4 weeks. Just list after 4 weeks. If it doesn't come, we will.
Well, that may be
Dispose.
recorded.
Huh?
That may be recorded.
On the next date fixed, if the respondent is not represented, comma, then the present petition shall be disposed of on its own merit.
God bless.
Yes,
Your Lordship, a record was called from the police.
what record?
Regarding the further investigation, whether charge sheet is filed or not.
Yes. Gitado.
Yes, this is at a stage of investigation. So investigation has to carry on.
That's why we are directed to obtain updated status on 10/6. 3 months back.
Status not received.
Why you have not? If you have not asked for, how can you receive? How can you receive it? Have you asked for it? So ask sir something, whether you have asked for the status, updated status or not.
I'm directed to our staff.
Yes,
I'm directed to our staff to send the message. I asked my staff to send the message.
thereafter you didn't ask your staff to inquire about your staff. Who is your staff?
Neeraj Singh.
Huh?
Neeraj Singh. Neeraj Singh.
Is your official staff or private staff?
No, he's
Call him.
police personnel.
Call him. Please call him. It's been 3 months. You have directed to obtain the status. Yes, call him after some time.
Your Lordship,
Yes.
In the previous hearing, the counsel for respondent number 2 to 16, they sought for some time to file their affidavit,
Yes,
and we have not received it yet.
you are appearing.
Yes, ma'am.
Yes,
I'm for respondent number 2 to 16. ma'am.
yes,
What happened in this case, ma'am? Some subsequent development has been come up.
yes.
Police have filed their final report. Final report.
Final report.
Yes, ma'am. Against that final report, I have filed one protest petition.
The matter doesn't matter.
Yes. Well, what I am submitting is that, madam, let this matter may be taken up after 4 weeks, madam. In the meantime, that protest petition may be, madam.
No, if the final report is filed
Yes, madam.
by the police,
Yes, madam.
nothing remains in this petition.
But, my lord, I have filed protest.
No, you have filed that against that
Yes, madam. I guess.
because no charge sheet has been filed.
Yes, madam. Against that, I have filed protest
That
petition.
will be, protest petition will be taken care of.
But, my lord, in my humble submission, madam.
Okay, that has not been decided as yet.
Yes, not this again.
Okay.
Because I am asking for further investigation. That's
So as of today, it's in your favor. Status is in your favor.
Hmm.
Do you understand what he has said?
Yes, Your Lordship.
Have you understood
Yes, Your Lordship.
what he has said? What he has submitted, what the learned council has submitted?
But the charge sheet has not been,
No, you are against quashing of the FIR.
yes, Your Lordship.
Now police has filed a final report
Hmm.
before the competent court, before the court. Now it is yet, final report is in your favor.
Yes, Your Lordship.
Now he has filed an protest petition. It is yet to be decided. So it's of no use.
Your Lordship, if FR is filed, then Your Lordship, there is no any question of quashing, Your Lordship. Later on, if suppose they file a protest petition and they agree, they have to challenge it, but not by way of Your Lordship. If FR is filed, that means there is insufficient material so far.
Yes.
So now the question of quashing doesn't arise, Your Lordship.
That's what I'm saying.
Yes, Your Lordship.
Now, in case if the protest petition is allowed, I mean, and he can always challenge that.
Yes, that will be subsequent development.
Revision, yes. Nothing survives.
In fact, become infructuous, Your Lordship.
You can challenge that. As of now, you are asking for quashing of the FIR,
Yes, Your Lordship.
right?
Yes, Your Lordship.
But then police has filed a final report, which is in your favor. Now they have filed a protest petition before the court, competent court. So if it is goes against you, you may challenge that order
Yes, Lord.
subsequently. As of now, it will be unnecessary. Yes, what do you say? We'll close it. We're giving the liberty, the parties
Yes,
to
of course, that liberty is always
approach
there.
in accordance with law.
Yes, sir.
In case in future. That's all. Because it would be proper.
otherwise, my lord,
We'll keep it pending.
yes, madam. Since my lord, today, madam, his her senior man has given letter.
We are
says-
not waiting for the senior. She is equally competent.
Okay. Then my lord, it can be closed, madam. With the
We'll
observation.
give a liberty.
Yes.
Liberty is there. It's not required, but then we'll just give a liberty. Any orders that may be passed by the competent court, the parties may.
Yeah, approach this court again.
All right.
Yes.
All right.
All right, Your Lordship.
Her MS so-and-so learned council petitioner. The petitioners, how many petitioners?
Oh, one on.
Petitioner. By filing this criminal petition, the petitioner has prayed for
My Lord, for record that FR.
has prayed for quashment of the FIR, prayed for quashing of FIR, being 0 PS case number 23/2023 under section 448/506 IPC, 1860. Please tell. Before that, you just heard so and so, heard so and so, learned counsel for it, and you just give that. Learned additional PP, TTL, and Mr. H. Lampu, learned counsel for respond number 2 to 16. Mr. Then you write that. Here. When the matter is taken up for consideration, the about the learner's additional PP and the learner's additional PP, Mr. T has produced the, what is this, deputy message?
Yes, Your Lordship.
Deputy message. The FIR. The FIR registered being PR 0 PS case number 23 of 2023 has been written in final report by 0 PS FR number 09 of 2023 dated 12/12/2023 before the court of CGM 0. Please stop. Next paragraph. Mr. H. Lampu, learned counsel, submits that against the filing of the submission of final report by the police, the respondents have filed a protest petition,
Yes.
which is yet to be considered and disposed of by the competent court. Please, next paragraph. Having considered the developments and considered that having considered the submissions of the learned counsel to the parties, and also considered that the case has already been returned in final report, which is before the competent court at 0. I am of the view that I am of the view that no further requirement and no further consideration is required in the present petition. Mr. Accordingly, the criminal petition stands closed and disposed of. However, since the five respondents have filed a protest petition, which is yet to be considered by the competent criminal court at 0, the petitioner as well as the respondents may avail the appropriate remedy in the event the protest petition is considered and disposed of by the competent criminal court.
Yes. Deeply obliged, Your Lordship.
Your Lordship, with liberty to file.
Yes.
Much obliged, Your Lordship.
The a copy of the deputy so and so, the kept in the record and marked as document X. Like.
Item number 5.
Yes. Have you discussed, have you asked him?
Yes,
What did they say?
the WT message was sent to the concerned PFs.
Where it is? So as,
But no response. Matter for the last time came before 10/6/24.
this was sent on,
Sent on
you said this WT message is pagination on or before 23rd February 2024. But court has passed in June, 10th of June 2024. So order.
Your Lordship, I apologize for there's a mistake on our part. So last chance may be given.
Sir, you need to do something more about yourself. This is not interest of the administration of justice. It hampers, rather. I'm not passing any adverse order today. Be careful. Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Yes, Mr. Tata, be careful next time. I'm not passing any orders today. But next time, if things continue like this, we may be compelled to pass certain orders. All right, be
Right.
careful.
Which others,
This court on 10/06/2024 directed Mr. Jitado, learned additional PP to obtain updated status. However, today Mr. Jitado learns additional PP. Initially, have stated that he has asked his staff, Mr. Dinesh Kumar Rai, Peskar. What is this? What is your post? Constable, who is assisting the office of the PP to ask to communicate and ask for the updated status. Mr. Dheeraj so and so was directed to appear before this court. Mr. Dheeraj so and so, Dheeraj have placed a WT message sent by the public prosecutor, Guwahati High Court Internal Permanent Bench, which indicates that the status report be sent. Status report along with all relevant documents be sent on or before 23rd/02/2024. list of. Having considered the submissions of the London additional PP and the deputy message, it clearly reveals that the London additional PP has not taken any steps for obtaining updated status despite the order of this court on 10/6/2024. Mr. Having considered such conduct, this court expect the London additional PP to act responsibly in future. Mr. Having considered the status of health of the Mr. Jitado, London additional PP, one last chance is granted to obtain the updated status report without the London additional PP is directed to obtain updated status of the case on the next date fix without fail.
Yes, yes, Your Honor.
All right.
Okay.
List after 3 weeks.
I will let you.
Yes.
Challenging the Your Lordship FIR, but non-appearance from the other side. Both petitioner and the respondent, private respondent.
Who is for private respondents?
Private, it's there in your office note, Your Lordship.
T. Topu. Who is for respondent? Petitioner?
Petitioner, Your Lordship, it's a Delhi-based advocate. However, Your Lordship, the local council's Lika Asa, perhaps, Your Lordship, is there in the record.
What is to be done?
Maybe Your Lordship posted after vacation then. Puja break.
None appears for the. T. Topu has filed an the
Affidavit in opposition.
no.
Wakalat now.
None appears for the petitioner as well as respondent number 2 and 3.
Yes, sir.
Mr. T. at London additional PP is present. List after 6 weeks.
Deeply obliged.
May I please, Your Lordship?
Yes.
Your Lordship, this is a joint petition for quashing of the GR number 2 of 2020. It's pending for the Chief Division Magistrate. My lord, the sections here are 143, 148, 149, and 324.
Yes, who is appearing? Yes, you argue the matter, will dispose of the matter.
Yes, Your Lordship. My
Who is
lord,
appearing?
Your Lordship,
The London additional PP is on leg in, who is looking after it, L Hage, Your Lordship. She's on leg in item code number 1. This may pass over for the time being.
What is there? 142, 148, 149.
140.
They are relatives.
Yes, Your Lordship.
Which
There
one is which one is non-compatible?
Sir, Your Lordship, all of 143, 138, they will go on non-compliant. But your, my submission would be, your lordship, these, the ingredients in all the sections doesn't fit here, your lordship.
It's a joint petition.
Yes, your lordship.
Then why you are,
Petitioner number
why you have to venture on that?
Not on merit, your lordship. If
If
it is
it's
on
on-
merit,
Yes,
the-
if it is a joint petition, then yes, you are good a matter.
Yes, your lordship.
We'll dispose of the matter.
Petition number 1, 2, 3 are the accused persons and petition number 4 is the complainant, your lordship.
Petition number 1 is
1, 2, and 3, they are the accused person, your lordship.
1, 2, and 3.
Yes.
Then,
Petition number 4 is the complainant, your lordship.
yes,
Alleged victim, your lordship.
Your
Lordship, may kindly come to the, come to page 18, your lordship. This is the FIR.
18,
Yes, your lordship.
yes,
This is the FIR, your lordship. May I read you?
yes.
To such and such, submission such and such. With due respect, I wish to inform you that yesterday on dated 13th April 2019, I went to New Hime village from my native village to visit my paternal uncle at time around 12 noon. When I reached at New Hime village, I did not find him at home, so I went to Hime village to find him. As I reached at Hime village, I saw a group of mob exchanging hot verbal arguments, and I saw all the episodes and tried to persuade as predominantly the villagers of the Hime village are my clan members, but none of the Hime villagers did. So I stand aside from the mob. While standing aside, one Sri Kominada, son of such and such, attacked me with lethal weapon. One Sri Martin Monle, son of such and such, attacked me, followed by Sri Ricky Meteor, son of such and such, attacked me with lethal weapon, and one Sri Jigam Nake, son of such and such, attacked me with the lethal weapon. Your lordship, here in FIR, 4 names are mentioned, and the main Kominada, your lordship, which the complainant has alleged that he attacked the complainant with the use of the lethal weapon. Because of which maybe the 324 has been registered, your lordship, section 324. But your lordship, during the investigation and in charge sheet, your lordship, the name of the Kominada, he was dropped. There were only 3 accused persons remaining. The name of the Kominada who allegedly attacked the complainant with the
It has been dropped.
Yes, name was dropped, your lordship. So remaining 3 were charge sheeted, your lordship. Charge sheet is at page 26, your lordship.
26.
Yes, your lordship. Page 29 is the report, your lordship. May I read, your lordship? The brief education history of the case is that on 14/4/2019 at 1500 hours, a written complaint was received from Sri Jabung Omne, his son of such and such, village Balisori, Likavali, Lower Siang district, Arunachal Pradesh, to the effect that on 13 April 2019, he went to New Hime village from his native village to his paternal uncle at time around 12 noon. When he reached at New Hime village, he did not find him at his home, so he went to the Hime village to find him. As he reached the Hime village, he saw a group of mob exchanging hot verbal argument. He saw all the episodes and tried to persuade as predominating the villagers of the Hime village are his clan members, but none of the Hime village hits. Your lordship, this is the FIR filed by the complainant. Then your lordship, next para, your lordship. On the receipt of the complaint, a case by such and such under section 143, 148, 149, 320 IPC, registered by OC Police Station, Likavali, and endorsed to me for case investigation. During course of investigation, I have visited the PO and the case name of PO has been drawn.
Yes, where is the agreement?
Agreement is
69 page.
yes, your lordship. It's at 69, your lordship, and it's still 5.
No, before that, you said you had a settlement, settled the issue,
Yes, yes, your lordship, annexed 3, your lordship.
election three,
Yes, your lordship. Type copy, translated copy is at
Page-
page 22.
22.
Yes, your lordship. Thank you. May I read your lordship?
Yes.
Deed of family agreement on dated 5/1/2020 at Hime Village, Campus Circle, under the chairmanship of Sri Jarchang Ngomle, head Gaupura, a mutual agreement was signed between two parties for a misunderstanding leading to altercations and small fight during the time of general election 2019. The list
And
of
what
the-
why you have said that you have been attacked by little wafer?
Your lordship, that is in the FIR, your lordship.
That's why you are the petitioner here, petition
No,
number.
your lordship, this is a joint petition. 1, 2, and 3, they were the accused person.
Yes,
And-
petition number 4,
Yes,
why
yes.
you have to allege that you have been attacked by a little weapon?
That is in the FIR, your lordship, before.
That's what I am saying.
Because-
On your FIR only this prosecution case has been set up.
Yes, your lordship, because your lordship, the case was not settled at that time, your lordship, 2019 between.
See, you cannot be allowed to file an FIR on your whims, on your own as a wish. You have put into to set the criminal motion.
Yes, your lordship.
Criminal procedure set into motion by filing your FIR.
Yes, your lordship.
And police has
Your lordship,
investigated.
At
Yes,
the moment, your lordship, it was
Since
out of emotional outburst, your lordship.
Injury is otherwise simple, your lordship, and it's caused by blunt weapon,
Yes,
not
your
by
lordship.
little one. It's a false
where the attack,
false
where
allegation.
it is,
Your lordship will find in page number 19.
19.
Yes,
Yes,
annexure 2.
That is the medical report, your lordship.
Simple.
Simple injury.
Simple injury.
Caused by blunt weapon, not by little one.
Otherwise, it's out of election related.
Yes, it's a family, and moreover, your lordship, even this their deed of settlement shows that they are family related. So considering.
How you are related?
Your lordship, the petitioner number 1 here is, he is the petitioner number 4, the victim, alleged victim, he is the uncle of petitioner number 1. And petitioner number 2 and 3, they are also close relatives, your lordship.
What close relation?
They are maternal uncle, apparently.
Maternal uncle.
Yes, your lordship, of 2 and 3.
Relatives are quite confusing. Relations are quite confusing. Anyway,
Yes, your lordship.
Lela, heard MS. Learned counsel for the petitioners and also heard Mr. T at the learned additional PP for the state. By filing this petition under section 482, what is this 482?
482.
482 of CRPC 1973. Now repealed. Bracket closed. The petitioner have jointly pressed for quashment of the criminal proceedings of GR case number 239 of 2022 under section 143, 148, 149 of the 322, 24 of the IPC 1860, now repealed, bracket closed, which is pending before the Chief Judicial Magistrate, Pasigat, against the petition number 1, 2, and 3, on the basis of settlement entered between the parties. Next. Next para, the case set up by the prosecution is that on 14/04/2019 at 1500 hours, a written complaint was received from the respondent number, petition number 4. To the effect that on 13/04/2019, when he went to New Hime village from his native village to visit his paternal uncle at that time at around 12 noon. At, at around 12 noon, when he reached at the said Hime village, he could not find him at his home. So he went to Hime village to find him out. As he reached the village, he saw a group of mob exchanging hot verbal argument. And he saw all the episode and tried to persuade as the villager of Hime village are his clan members. But none has paid any heed to him. While he was standing near the move, away from the move, standing besides the mob, the petitioner number 1, 2, 3, and 1, Mr. Who has been dropped?
Your Lordship, commonly nada. It has been mentioned there in the file.
Petitioner number 1, 2, 3, and 1, 3, Komni Nada attack him with lethal weapon. One Komni Nada and others have attacked him with lethal weapon on his head with an intention to kill him without any provocation. Next, on receipt of the FIR, a case was registered being Likabali PS case number 5 of 2019 under section same IPC so and so. Please stop. On completion of the investigation, the police has filed the charge sheet against the petitioner number 1, 2, and 3, and 1 Sri Komni Nada has been dropped as was not found to be involved in the case. Next para. On the perusal of the please stop. Perusal of the records, come up. It is a perusal of the records, come on, goes to show that the investigation goes to show that on 11 April 2019, the polling of 20 Sogum polling station was proceeding as per the authority of the election department, election commission. Government of India. But some supporters of BJP political party alleged to have broken the EVM machine of the said polling station. Therefore, the recall of 20th Sogum polling station, it is assembly or parliament?
General Assembly.
Assembly election, huh? Friends, on 11th so and so during the assembly election, huh? The polling of 20 Sogum polling station. You're right. The repoll of the 20 Sogum polling station was demanded to be refixed. List of on 13 April 2019, the political supporters of BJP party, consisting of near about 40 supporters, led by a contesting candidate of the BJP political party, arrived at Hime village to visit their party supporters. Party supporters at the time when the MCC, no, Model Code of Conduct of Election within bracket, the MCC, was in currency, wherein the Election Commission has directed to avoid any political party, to avoid any campaign by the political parties. The supporter of People's Party of Arunachal Pradesh stopped them at the entry point of Hime village and asked them not to enter the village for conducting any election campaign. Thereafter, some argument followed by pulling and pushing was created in between both the parties. Wherein one city, Jabon Momle, a supporter of BJP party, had sustained simple injury. Next para. It is taken note that during the thereafter during the pendency of investigation and before during the pendency of investigation, the parties have entered into a family settlement as the petitioners, as the complainant and the accused are relatives. The settlement, please, no, please, the mutual agreement was signed between the parties petitioners under the chairmanship of one city, Jarcham Gomle, head GB. On when it is,
5/1/2020.
How do you know?
5/1/2020.
where is the date?
Uh,
Okay, on 05/01/2020. Whereby the petitioners, being a close family relatives, have decided to settle the matter mutually by way of customary, Gallo customary law. List of. Thereafter, the next paragraph. MS permit learned counsel to the petitioners submits that after the settlement of the matter, when the petitioners were living peacefully by maintaining a cordial relations, being a close family relatives, you have received a summon.
Yes,
The petition number 1, 2, 3, the 1, 2, and 3 have received the summon
Uh.
from the court.
Your Lordship, only petitioner number 1 and 2.
Okay, the petitioners, petitioner number 1 and 2
Yes,
have received a summon from the court for appearance,
for appearance.
as the police has already filed a charge sheet. This stuff. Before the court, against the petitioner number 1, 2, and 3. This stuff. She submits that after receipt of the summon, did you appear? Have you appeared?
No, Lordship. not-
Why?
This is the first summon, Your Lordship. Thereafter, they have come to.
So first summon you don't appear.
Because, Your Lordship, they have come.
Anyway, submits that having received the summon, as the parties have already settled the matters before filing of the charge sheet, again, the parties on these petitioners on 24/05/2024 have entered with further settlement which has been duly registered. List of. Therefore, she submits that since the parties have already settled the matters twice, one before the filing of charge sheet and another after the filing of charge sheet by the police, there's no the chances of conviction are bleak. She further submits that the injury is of simple nature. As per the injury report by the medical officer. And research request for quashing of the criminal proceedings against the petition number 1, 2, and 3. Next paragraph. Mr. Theatre learned additional PP in his usual frankness submits that since the parties have already entered settlement between them and the medical reports, the injury report shows that shows the nature of injury as simple, comma. This court may pass appropriate orders in the interest in the interest of justice. That's all. Consider the submissions of learned counsel for the so and so. Huh? Next paragraph. On consideration of the materials, comma, it appears that the incidents of Alice attack has arisen due to political rivalries in during the assembly and the parliamentary election in the year 2019. List of it appears that it appears that both the supporters of rebel political parties have engaged in the incident. List of the in the process where one person has sustained simple injury. Mr. Next paragraph. It is also not taken note that after the filing of the FIR, the parties have entered into agreement, a settlement on 05/01/2020 under the guidance of the head governor of a village as the petitioners are close family relatives, and thereafter they have maintained a cordial relationship amongst themselves. Mr. Next bill. The charge sheet clearly indicates that where is the charge sheet?
Actually, page 26.
26.
Yes, Your Lordship.
indicates that there is an argument between the supporters of rival political parties and followed by pulling and pushing between the supporters of the political parties. And in the process, one person has received an injury, who has sustained a simple injury. Having considered the attending facts in the present case, this court is of the view that since the parties have since the parties have settled the matters which is arisen purely out of election related issue between the rival political parties, and considering that in the process one person sustained simple injury, though considering that one person has sustained injury, as well as the parties have settled the matters and are maintaining cordial relationship, being the close family relatives. I am of the view that the proceedings, the present proceedings would end up nothing but would be abuse the process of the court, as there is a chance of, there is a unlikelihood of conviction of the petition number 1, 2, and 3. When you next paragraph, in the case of so and so, what is that?
Lakshmi Raman.
So and so, you just quote all this thing. Is there, I think, some other topic from that. Next paragraph. Having, in view of the discussion 20 hearing ago, and considering, in the light of the judgment of the Honorable Supreme Court, and in the light of law enunciated by the Honorable Supreme Court, I am of the view that the present case is one of the cases where the inherent power of this court is fit to be exercised. Accordingly, so and so, criminal proceedings so and so, so and so, pending before so and so, so and so, is hereby set aside in trust. The petition
So one small correction.
is allowed.
The FIR is number 15 of 2019. And
What I have said,
Your Lordship, it has been wrongly reflected here in the charge
you
sheet.
said
Page 20.
FIR
It is 15 of 2019.
registered as Likability case number
15.
15 of 2009.
15 of
Just
19.
correct that in there.
And also, Your Lordship, petitioner number 2 and 3 has received summons. That was
2 and 3.
2 and 3 has received summons.
Obliged.
Obliged, Your Lordship. Your Lordship.
Dispose of. Petition is allowed and disposed of.
Lordship may kindly pass over the matter.
as the counsel is on his leg at courtroom number 1.
So bail application, your lordship. Also bail application, your lordship.
Rejected.
Yes, Lordship. I have to consult my seniors.
You tell him that court is rejecting the bail application. Yes, next.
Obliged.
My pleasure, Lordship.
Yes.
Here, step was taken to the respondent number 1, who is implemented as a new respondent number 1 in place of his deceased father. So step was taken, but same could not be ascertained. I may be allowed to take fresh steps to respondent number
No,
1.
learned counsel but the applicant has not taken steps for service of notice upon the respondent, newly implemented respondent. You have not taken.
But I have been instructed by,
Will it impose a cost?
yes,
Show him.
no, I have gone through your laws.
Yes, then
On record, it is not found. So therefore, I may be allowed.
since despite the order of this court, since Mr. Boje has failed to take steps, despite order of this court, a cost of rupees, how much?
Lordship, actually, I have taken a step, but the clerk who was engaged,
We are not concerned.
yes,
You have to be careful.
it has not brought on record. That is only the reason.
Are you a clerk is a court officer? I mean, court official?
No, no.
Then on the prayer of Mr. D. Boje, no, you read office note dated 17/09/2024 reflects that the learned counsel for the applicant has not taken steps for service of notice upon respondent, newly implemented respondent number 1.
Number 1.
Please stop. Next para. Mr. D. Boje, learned counsel for petitioner, press for and is granted 2 days time to take steps for service of notice upon respondent number 1. List the matter after 4 weeks. You take within 2 weeks, 2 days.
There is interim order.
Interim order passed earlier is vacated. Vacated.
No.
Continue.
Obliged.
Yes, madam.
Your
Press
Lordship,
steps not taken.
yes, your Lordship.
Office note dated 17/9/2024 reflects that no press steps have been taken by the learned counsel for the petitioner. The MSO learned counsel for the petitioner is granted further 2 days time to take press steps. List after 4 weeks.
I'm appearing on behalf of respondent number 6, madam.
You write, Mr. So-and-so appears for. You are for?
I'm for the state, your lordship. SIT is,
Edi-
in SIT
Mr.
is not present, I am
Mr.
appearing.
Mr. M. Kato, learned counsel for
Other-
DSJ,
DSJ, madam.
learned DSJ, and Mr. T. at the learned additional PP are present.
The-
Ever service reports. In respect of respondent number 5, 7, and 8 for further 3 weeks.
Lordship, interim is there, interim.
Learned counsel for the parties are present. Interim order was earlier shall continue.
Lordship, difficulty in this case is that so far we have taken 9 steps. 9 times step has been taken.
We'll wait some time. Then you have to go for publication.
Yes.
Paper publication.
Yes.
Yes, next.
Item number 14.
Who is respondent number 1?
Respondent number 1.
In respondent number one,
You may go send someone else, because you have to type that also. Office note dated. Okay, just write this. Office note dated 17/09/2024 reflects that service is complete in respect of respondent number 2. However, awaits service report in respect of respondent number 1. This after 3 weeks.
Lordship,
This
in
after
interim order is there.
3 weeks awaiting service report upon respondent number 1. Interim order passed earlier shall continue.
We have license.
Orders make it fast.
Lordship. Lordship, as per the office note 17/07/2024, the service to the respondent is completed.
Your Lordship, I'm for respondent number 1.
You're for respondent number 1.
Respondent number 1.
What about 2?
For respondent number 2, on the last occasion, Your Lordship, the service report was incompleted. As of now,
Now it's complete.
Yes. Yes, my lord.
Just wait. Let it. How many EPS? 4. 1 I have engaged. One I have engaged, but 3. All again. All over. Your job is over. Or Mr. So and so, learned counsel for you. Mr.
H. Sakum.
Learned counsel enters appearance on behalf of respondent number 1. None appears for respondent number 2. The service is complete in respect of respondent number 2. List for admission hearing after 3 weeks. After 3 weeks.
Okay, my lord.
Obliged, my lord.
Yes.
A service report is for respondent number 2 awaits.
Awaits service report in respect of respondent number 2 for further 3 weeks.
Your interim granted may be continued.
Interim order passed earlier shall continue.
Obliged.
My lordship.
Yes.
Lordship, this is a criminal joint petition filed under section 482 of CRPC.
Heard Mr. So and so learned counsel for the petition and also Mr. T at the London additional PP. Sir, the records have been received. A scanned copy of the record of GR case number 0919 is received. List for admission after 4 weeks.
Deeply obliged.
Deeply obliged. Mr. M. Pertin. Mukbam Pertin. Mukbam Pertin is present for the petitioner. And Mr. Opada. Special PP.
My lord.
Learn a special PP. You just learn counsel for the petitioner. Learn counsel appears for the petitioner. Mr. Opada, learn special PP, SIC,
SIC vigilance.
within bracket, BIG, bracket close, is also present. Office note dated 17/9/2024 reflects that service in respect of respondent is still awaited. Next para. List after 3 weeks awaiting service report in respect of restaurant number 2 for further. No, awaiting service report in respect of restaurant number 2. Same order. Respond number 2, same order.
We can take up
Then
the
you change this.
maintainability issue. If we can take up the maintainability issue today. We can take up the maintainability issue today. If your lordship pleases.
Why?
Maintainability, because basically the case is pending because of the maintainability of the petition.
So first service has to be received, service has to be completed.
If they are on maintainability or if maintainability goes, everything goes, they are protected as on that.
So why it's not maintainable?
We are saying it's not maintainable.
You file an objection. You file an application, objection.
Yes, that was kept open by this honorable court by the
It's
only.
okay, you
Yes,
file
Lord.
it.
Because
Or Mr. M. Pertin, Mukbam Pertin, learn consent for the petition. Petitioners. And Mr. T. learn consent for the learn additional PP for the state. Office note dated 17/09/24 reflects that service in respect of respondent number. Service report in respect of respondent number 2 is still awaited. List after 3 weeks.
Yes, obliged.
In the meantime, learn this addition may.
You will argue from the record, your lordship. From the record, will argue, your lordship. Because your lordship is a well settled law, your lordship. The judgments are there of the apex court. So we are basing on that, we'll argue, your lordship.
Much obliged.
Obliged.
Don't forget it.
Interim has been granted, that may be continued.
Interim order pass earlier.
Yes.
Same. Yes. 17 interim. Status report, CGM Pasigat.
Yes, my lord, this is joint application. Joint application filed by
Yes.
petitioner number 1, 2, 3 are the accused person in charge sheet, Your Honor, and 4 is the complainant wife, Your Honor, of the petitioner number 1. They have settled the matter, Your Honor.
So,
and they before, Your Honor, local Kava, Your Honor, on dated FIR was, Your Honor, lodged on 25/03/2016, Your Honor. and matter was settled before the local Kava on 2703.
This court has directed for status report. All pen, let the status report of the case who is appearing. Item 20.
Yes.
Again, status report.
Not, not received. Status report not received.
Have you asked for it, sir?
This time we.
This
failed
time,
to-
not only this time, last time also you didn't ask. Other case also you have not asked.
Actually, we used to
Yes, Mr.
practice pan noting.
Tapin,
We used to,
theatre. Courts are passing, directing to obtain instruction, report, status report. You are not doing anything. Last time, Mr. J. Singh appeared. Whatever status report of the charge sheet in Nari PS case from the Court of Judicial, Chief Judicial Magistrate.
And so far as the status is concerned, charge sheet is filed,
No, I'm not the status of the case. Status of the case could be before the court also. Anyway, the heard Mr. So-and-so, learned counsel for review. Office note dated 17/09/2024 reflects that the status report called for from the CGM Pasigat, Court of CGM Pasigat is yet to be received. List of registry to send reminders. Send reminder, huh? Registry to send reminder. List after 3 weeks.
This is for the quashing of, let this be fixed for admission hearing after.
Why? Yes, they recall for. Huh? This is what?
For quashing of FIR.
Quashing
The
of
ground of
FIR.
compromise.
On settlement, your lordship.
On settlement.
Now it is, the matter is an investigation stage, your lordship. That's the issue.
Let me also wait. Yes, there was call for.
Yes, your lordship, I have the copy
You
of
have
it.
that.
Copy of it. So now, your lordship, here the issue is, your lordship, since investigation is in progress. So what my humble submission would be, let the investigation completed, your lordship, whether there was any foul play or not, because 3 persons has died, your lordship. So this is the issue at this stage, your lordship. Now facts are hazy. If once the investigation is complete, everything would be clear, your lordship.
Heard Mr. DK, they learned counsel for the petitioner. Petitioners,
Yes, petitioners, joint petitions between the
Uh,
complainants.
Mr. T at the London additional PT has received the scanned copy of the case there.
Yes, your lordship.
And submits that the investigation is
In progress.
in the initial stage. Excellent. Considering the above, that this matter be listed for admission hearing
Yes.
after 4 weeks,
After, can it on pick 8 of October, 28,
20,
28.
28.
Deeply obliged.
Oblate.
Meet your lordship.
What is this, sir?
My lord, in pursuance of the order that is 16, my lord. The earlier petition was withdrawn and this is a fresh application for condonation of delay, my lord.
Issue notice 365 days.
365.
Heard Mr. Tish on learned counsel for the petitioner. And learned counsel for the applicant. Next para. This is an application under section 5 of limitation, Indian Limitation Act 1963. Praying for condonation of condonation of delay of 365 days in filing the connected second appeal against the judgment and order dated 14/09/2022, passed by the District and Session Judge, West Coming District, Bombilla. In regular
Regular
civil,
parts, okay.
civil,
03.
appeal number 03 of 2023. Issue notice returnable by 4 weeks. The learned counsel by the petitioners to take steps for service of notice upon respondent number, sole respondent by registered post.
ADA card as well as the
That's
justice
it.
are.
As well as by dusty mode. List after
Much obliged.
3 weeks. What do we say? 4 weeks or 3 weeks? Returnable?
4 weeks.
4 weeks.
Oh,
Yes.
But though this has come for hearing, it appears there was never any order for preparation of paper book. Records have come, it may be inconvenient for your lordship, so. We'll bear the cost, my lord, I am the father of the.
Yes,
deceased
here,
person.
your lordship, state is pro forma, your lordship, because it's appeal against the acquittal. We are not agreed by it, your lordship.
The service is complete.
Service is complete.
Complete, your lordship.
Mr. Pertin is
Mr.
appearing.
Pertin is the counsel for the.
Because of service, it was quiet, it has been pending so much.
So we'll just direct it to
Paper book.
the cost shall
Yes,
be there by,
yes.
borne by the rest. Heard Mr. Deepang, learned counsel for the, and also heard Mr. T at the London Registered PP for the state, non-appeals for the petitioner. No, the respondent.
Respondent, your lordship.
Respondent number
Respondent
2.
accused.
Respondent.
Respondent acquitted person.
Refuse, respondent. Respondent number 2 or 1?
Respondent number, your lordship,
One, man.
1, yeah, respondent number 1. Registry to prepare the paper book, which, the cost of which the appellant, petitioner shall be borne by the petitioner.
Yes.
Petitioner, revision petition, right?
No, your
No,
lordship,
appeal,
criminal appeal.
Appellant, then in that case, appellant. List after
Preparation of paper.
preparation of paper book.
Deeply obliged. sir.
Metal.
Yes.
This is a very, very peculiar case, man. There was no plaint. Nobody approached the court.
So we'll call for the records.
Records have come, man.
Records is there.
Yes, admittedly, my lord, I have annexed the records.
Yes.
Admittedly, there was nothing. Nobody approached the court. There was some issue pending before the learned deputy commissioner.
That
The-
was transferred.
It appears so, along with the file
But,
notice.
the learned FTC has said so many summons were issued.
I have annexed the records also.
That's why we would like to know whether this.
The records are here.
Notice
Only,
were served.
only one notice, it appears to have been received by one of the Gaon. But we were parties in the complaints, with all these complaints before deputy commissioner, the appellant hearing. No notice was issued to us, record that clearly reveals that. And that apart, no evidence was adduced on their behalf also. It is reflected in the judgment itself. In fact, the learned trial court has come to a finding that they have not made out any case. So even if assuming under the, he can proceed ex parte, does it mean that you give a go by to everything? No points, nothing. There's the Supreme Court is very clear on that. If your lordship sees the judgment itself, that will be enough for having it set aside.
Yeah, I've seen it.
Hmm.
Judgment I've seen, but
Yes.
the synopsis I get confused. Somewhere it appears to be by the Gomdir village, sometimes it is by the Tarin village. When I read this,
Well, because
the synopsis.
there were various
yesterday.
facts that,
Yes.
which are actually irrelevant. Apparently, all these complaints and all the proceedings that was pending before deputy commissioner,
Some
that
other,
was taken cognizance.
some other day,
Other day.
first week. Or
In that case, after the vacation.
Next or
After the vacation.
There's no urgency.
No. No
It's,
urgency.
they are not cultivating now.
That I have no idea actually.
Okay. No urgency.
Yes.
After vacation.
Since this is forest areas.
And Mr. Deepang Learned Council for the appellant, and also had Mr. K. Learned Council for the respondents. This the matter after Puja vacation.
This is the preparation of paper. Obliged. Otherwise, this is very, very peculiar.
Yes, yes.
This is jail appeal
Yes.
against the conviction under section 304 part 1 of IPC. Sentence for 10 years with a fine of rupees 10,000. My lord,
So what is the ground?
ground is, my lord, no one is the eyewitness of the commission of offense. This is the only ground. Otherwise, Your Honor, during the framing of charges, he admitted.
Circumstantial evidence.
Yes, circumstantial evidence, and some of the witnesses also, Your Honor, some of the witnesses are stated in deposition that after the commission of offense, he escaped, Your Honor, from the PO, Your Honor. So after 3 days, he was arrested.
There was no witness.
There is no eyewitness.
Eyewitness.
Yes.
Okay.
One of the witness stated that on the instruction of on the instruction of the owner of the farm, actually a victim and this accused person convict are the related to each other. They are the this was the sister-in-law of the this convict, and they were living together in the same house. Someone's farm, Your Honor, informant's farm. When the informant's wife instructed one of the laborer to visit the this house just to whether she is fine or not, Your Honor, since his husband is in the jail in some other cases. So on instruction, Your Honor, one of the witnesses visited the house of the victim disease and found that the accused person and his her daughter, deceased daughter, were having breakfast, and disease was lying on the room, Your Honor. So she thought that she was sleeping, and he went back. After that, Your Honor, he informed the other laborers that this disease is lying. She might be having some health problem. And after some time, all the laborers came to the house of the disease and found that the disease found dead. Okay. At that time, the accused person was not there. This is the only ground. There was no eyewitness. And he admitted his guilt during the framing of charges. And even under section 313 statement also he admitted.
Admitted.
Yes.
313.
Yes.
Let's see. Where is 313?
313, page number 67.
Yes.
Second question. Question was, can you tell what the incident was and how the disease died and what was your relationship with the disease? Answer is, it is the fact that I had a physical intimacy with the disease and during the night of the incident, and the disease poured hot wine in my glass, for which I lost my temper and assaulted the victim by strangulating her neck. The incident took place in the night at around 9 p.m. and the disease died at around 12 noon on the next day of the incident. And as per the doctor, postmortem report, also, Your Honor,
There's nothing in that case.
yes.
Where's the PP? So in that case, some other day.
Yes.
And there's nothing. There's
Yeah.
nothing also.
Nothing. It's admitted in 2 times. Your Honor.
You have some research more.
Yes.
If there's
yes,
anything,
Yes.
despite having this 313. 164 is there.
No, 164 is not there, but during the framing of charges, he was admitted, Your Honor.
Paying of charges also.
Yes.
Then,
Even Your Honor.
then why trial has
for
to
the-
proceed?
Yes, Your Honor.
At the
That is,
time of trial, if he is admitted.
yes. In page number 43, in paper.
43.
43. 43, it is there.
Oh. He has pleaded guilty.
Yes.
Why the trial has to proceed in that case?
Yes, Your Honor, that is the
The conviction is under
conviction is under 304 part 1.
304 part.
Yes. And Your Honor, if
Think
the,
about, you have some, we'll go into again.
yes,
Sir,
my lord, if the accused pleaded guilty, Your Honor, and as per under section 75 CRPC, Your Honor, appeal is not, Your Honor, no, page number, section 375 CRPC, no appeal in certain case when accused pleaded guilty. So notwithstanding anything contained in section 374,
No,
where
if
accused
you,
is,
if pleaded guilty,
yes,
any further proceeding is required, trial is required.
it is not required.
Maybe because
Then and there it can
he
be
had said
convicted.
that he did not have an intention to kill her.
Yes,
Maybe because of that. You go into it.
yes,
This is something which I mean, on merit, there's nothing.
yes.
On
On
the
merit there
question
is-
of if the accused pleaded guilty, it's an elementary.
Yes,
What is to be done? But in case with a pleaded guilty with a certain condition, what would be the proceedings, next proceedings, right?
yes,
And on that point, you just
yes,
work it out. Let us learn together.
yes, yes, ma'am.
This is strange. Admitted, pleaded guilty, and you have to go for. There must be something more than what we see here.
Yes.
You kindly go through it.
Hello.
And MS J. Dozy, learned legal aid counsel for the appellant. Non appears for the state. Will not record that, whatever you go into you not take note of those points.
Yes, sir.
You read the charge. He said pleaded guilty, but then he said he has no intention to kill her, right?
Yes,
And then 313 he has admitted.
yes.
In such circumstances, what should be the correct position? Because we need to correct the procedure also.
Yes, sir.
If there's something wrong. But on merit is very different.
Yes.
Okay. You inform her. This point you note it down and inform her also. She might have seen the thing, charge sheet and the 313 statement. charge, framing of charge. He has pleaded guilty, but then he said he did not have an intention to kill her. Right? That's why 302 is, it's not there.
No,
The charge has been framed.
Yes,
That's why
Charge frame under section
convicted,
three-
yes,
302.
convicted under 304.
yes.
Next that you have to apprise what is the procedure in such situation. No, next date. List after. So on the prayer of, in view of the absence of the learned additional PP. Come on, list this matter after 3 weeks. 3 weeks.
Yes.
Because I think first week there may be a problem. After 3 weeks.
After 3 weeks.
I beg to mention item number 9, my lord.
Why?
Firstly, my lord, I tender my apologies. My senior was standing on his legs in court number 1. My lord, a fixed date may be given, my lord, so that we can.
It is still busy.
Yes, my lord. So I'm praying on his behalf, my lord, that on 25 it may be fixed.
On the prayer of so.
Yes.
Item 9. Then it was.
Or this, it was a bail hearing, my lord. Yes.
Later bail only. Later note only, I've said. We said keep it for, take it after some time, I said, yes. So it's not possible today.
My lord, it won't be possible maybe.
Okay.
And yes, my lord.
On the prayer of London Council, Mr. London Council for the applicant list this matter after 2 weeks.
My lord, can it be fixed? Because my lord, on that day.
You are here only.
Yes, my lord.
After 2 weeks.
After 2 weeks, my lord. Deeply obliged.
Yes.
May I please, your lord? RFA,
Yes.
by filing this RFA, so the appellant placed before your lordship
Yes.
to especially leaving apart other grounds, my lord.
Yes.
So I beg to submit that the money suit was filed in the year of 2002. 2002. And from that is 7 October 2002, and thereafter it was pending till 2013. Till 2013. The 2013, it was referred from DC office because during the 2002, during that period, there was no judiciary, and it was pending. Even the
Judiciary was there. 1947 till there was a judiciary.
No, in Aruna, separate judiciary
Before
was
that
not.
also.
Yes.
Before that also.
Due to
But Indian judiciary came into effect.
yes, no. In the year 2013, it was referred. So in the total claim amount was 65,67,000. So same amount was granted in a decree.
So where is the law that same amount cannot be
No,
granted?
I am not going on that.
Okay.
So my issue is that the interest ought to have been imposed since 2013, my lord.
That's all.
Yes, 2013, because from 2013 only real proceeding was initiated and conducted, and since 2013.
2013. Till when? Till final payment.
Till the date of passing decree and judgment. Till the
When is the decree?
because the pending was
for pendency light, the company was not liable. Because even in between, the COVID pandemic period was starting since
When it is,
2019 to 23.
yes, where the judgment,
It's at page 68.
page
68.
68.
yes. This is on.
So
18 September. 18 September 2023.
2023.
Yes, shortcut. What is the interest?
6% only, Lordship.
Where it is?
We are not disputing, my lord.
No, where it is?
This is
It is
page,
last
Lordship,
page.
Page,
kindly come 84, Lordship.
page 84.
Yes.
Yes.
I am not disputing the
6% is the minimum interest,
6%,
Lordship.
my lord.
No,
But-
what is saying that from the date of, from 2013, when it was transferred.
Yes, yes. Yeah, the case
Transferred to
to the civil judge, senior division,
civil judge.
from DC office.
Lordship,
You'll get 10 years.
Lordship.
Yeah, yeah.
It Lordship
My
see.
lord.
Here the Lordship, they have reputed our claim. Lordship,
So will increase 8% from the year 2013.
My lord.
Till final realization. Till finally it is paid. Till finally it is realized. What do you say?
8% instead of 6. 6% maybe increase.
You are not pressing other grounds.
Yes.
You are not pressing other grounds.
The basic other grounds are there. I am not highlighting here because
No,
highlighting.
that's what I'm saying.
Yes,
Are you
yes.
not pressing the other grounds?
Yes. The other grounds are that.
It's a regular first appeal.
Yeah, regular
If
first
it's
appeal.
not pressing,
Uh,
if it is a the of interest part,
here, Lordship, why they are not pressing, Lordship? Because during the trial, Lordship, they filed written statement, Lordship, but they did not produce a witnesses, Lordship.
it's okay.
Written
It's
statement.
okay. We'll not go into the merit.
Therefore, on merit, Lordship, there is no ground to appeal also, Lordship. It's not the case that, Lordship, they have not given opportunity to adduce the evidences, Lord. This is not the case here.
They are
appeal.
trying to dispute that it violates the policy.
My lord.
Lordship.
The
Yes.
other girls they
Yes,
take
Other,
yes, yes.
and that was, Lordship, it's onus is on lies on them
yes.
to prove
If
that.
how it is how it has been violated, you have
No,
to
sir.
prove it.
My
That was
lord.
not proved, Lordship. The intention, Lordship, there's a delay, Lordship.
No, that's why I'm saying. Anyway,
My lord.
My Lordship, humble
this
submission.
only
I
where is
I understand.
2013
Lordship.
2013 onward,
till,
the interest
till,
would have
till
been
the
imposed
federal
till the date
judgment.
of decree, passing decree.
So I suggest you 8% from 2013 to till realization, while till finally it is realized. I mean paid, executed.
Basically, Lordship,
50% has been paid,
Yes, 50%
yes.
awarded amount, including interest paid.
including 6% interest.
Yes.
No, interest has not been paid.
No,
15% only. 50%
50%. Yeah.
is directed by this court
Yeah,
only.
this-
Yes, yes, paid.
And that has
So-
also been withdrawn.
Yeah.
So what do we say?
Lordship, basically, the interest has to be given when the claim is repudiated, illegally repudiated by
See,
the.
reason is I'm saying,
Lordship.
which is received by the Oriental Insurance Company.
Yes, my lord.
If we, of course, I should not say, since he is not pressing,
No,
on consent will decide,
Yes.
dispose of the appeal,
no,
if you agree.
no, sir.
Otherwise, practically, may invite further litigation.
My lord.
That I should not say, that is not the lookout of this court.
No.
But then sometimes we'll have to go by practicality.
Because my lord, this is a non-joint.
Because he's not
Yes,
pressing anything, any grounds,
No, sir.
except for the
Yes,
period of interest.
interest.
What do you say?
That part, Lordship, I understood, Lordship. There's a two set of judgment, Lordship, I brought, Lordship. One, Lordship, when the Lordship, the party failed to enter into the witness box to prove his case, Lordship. And that can be a ground for Lordship, presuming that Lordship, he has no case, Lordship. There's
No,
one.
I think he's indicating that he has no case.
Yes, yes. That's one just I'm appraising someone. Apart from that, another Lordship, one judgment is there, Lordship. 12% from the date when my claim was repudiated by the insurance company, 12%. Till realization. Honorable Supreme Court, Lordship, it was upheld, Lordship. Anyway, this here, Lordship.
Case. In other case.
No, in other case, Lordship.
Or in this case.
No, not in this case. Not in this. Another case, Lordship. There's also the fire policy in fire policy. So here, Lordship.
From the different jointly or severally only states should to date of decree.
As a matter of principle, Lordship, either from the date when the claim was repudiated or from the date of suit, Lordship.
We'll make it, and if you agree, we'll make it an consent order.
Then 10% from 2013, Lordship. Without any instruction from my client, just I'm giving consent here.
It's almost the same thing.
10 years also a very long period.
Because
suit was filed in when?
2001, Lordship.
Then it's almost the same thing.
No.
10% and all the
10%, 2001 to 2013, Lordship. 13, Lordship, 12 years. Lordship. He's seeking for omissions of 12 years, Lordship. 6%.
No, then another till 2000.
I'm increasing only the 4% only for Lordship. Another 10%, Lordship.
If you agree, in between 8% from 2013 to 2023.
May I propose, Lordship?
Or you may take instruction.
10%, Lordship.
No. You have offered him 10%. He
I think my brain will.
This court has offered 8%. 10% from 2013.
13. That's why I'm giving the counter offer, Lordship. Here also, at least some more amount is being lessening here, Lordship.
Then, my lord, I will have to take instruction. Because I am not going to the other grounds.
Lordship, why I'm submitting, Lordship? On merit, Lordship, they don't have ground for appeal, Lordship, because they failed to prove their case, Lordship. On merit, Lordship.
Because it's
And so far interest is concerned, Lordship, they are seeking omissions of, Lordship, 12 years, Lordship. It's a huge amount, Lordship.
That's why I'm asking. I'm not asking that this will be a kind of determination and will pass the order. I'm asking if you agree.
Yes.
If you agree, then only we'll pass. Yes. So that we'll record that consent on the consent of the parties. Otherwise, if we have to decide on merit, he wants that it should be decided on merit. What do you say?
Yes, on merit.
On merit, we'll decide.
Yes, sir. Yes, my lord.
Is it?
No. My brain.
Then on merit, if you want me to decide why you are proposing this 6% or something like that.
6% we are not disputing.
No.
Only
from the period.
omission of time.
So you said, without going into all the merit of the appeal of the matter, you are only praying that if this can be reduced, the period of interest can be reduced from 2013.
Yes, 2003.
That's why we're on your proposal only we're asking him if he agrees, though you have asked for 6%, the court has also given 6%, will reduce the period but will increase the interest.
8%.
8%. He is proposing 10%.
The insurance company, Lordship. Only I'm asking for another 2% only, Lordship. That too from 2013.
My lord, I will have to take instruction. Instruction, I mean, instruction. Then.
Otherwise, if you are not pressing we'll dismiss the appeal. If you are not pressing on other grounds,
yes,
We'll dismiss the appeal.
And so
Matter
far,
is there.
so far interest is concerned, Lordship. The
Other
ground,
grounds are there, my lord.
no sufficient ground is there, Lordship. Why the interest should be reduced?
Think about it. On 26.
Lordship.
On 26.
On 26.
No, no, it's up.
26.
Yes, it's up.
Matters, this regular first appeal has come up for final hearing. Come up for final hearing. Mr. Udeka, learned counsel for the appellant at the outset has submitted that he may not press the grounds of the appeal if the respondents agreed to if the respondent accept the interest to be calculated from 2013 to till the date of decree. List of Mr. Estafil has suggested that if the period is reduced from 2030, if 10% interest is if the interest is increased to 10%, you would not have an objection for the interest to be calculated from 2013 till decree. List of
Yes.
On such submission, list of in response to the list of Mr. Udeka on such submission of the just proposal of the Mr. Estafil and concept for the respondent come up fresh for a week's time to fresh for it a week's time to obtain instruction list of accordingly. Praise the Lord. List the matter on 26/09/2024. If not, we'll go for
On merit.
hearing on merit. But it's of no use fixing the date on your proposal if we had to go for
Yes,
merit. Think about it.
yeah, hello,
All right.
obliged.